All right, welcome. It's the Rains Feldman Cyber Liability Update. I am Eric with Scott on my left and Steve on my right. We'll just go with first names now since we've been at it a while. This week's topic, gentlemen, I want to speak to the audience out there about criminal investigations. Scott, you and I this year have had a number of cases where we get involved representing executives with regard to various criminal investigations, typically by the U.S. Attorney's Office. Now, the cases tend to involve our area of expertise, which would be business and the technology business, and the claims range from things like the Foreign Corrupt Practices Act to other wrongful business endeavors to privacy issues. And so, Scott, you're the star of the show this week, and what I want to throw out to you is, if you are a business executive out there, you've been involved in some sort of business dealing with someone who is the target of a federal investigation, you are subpoenaed to testify before a grand jury. It's obviously upsetting and you're scared. Aside from calling you, what should our viewers and business executives out there know about how to conduct themselves?
Yes, so when people think about criminal law, they tend to only think about the defendant, the person who's alleged of committing a crime, but much more common is that people are contacted by the U.S. Attorney's Office or some type of federal agency as a witness. There's many more witnesses than there are people accused of crimes. And so witnesses, they tend to be scared, they come to us, they're worried, and usually what happens is that we try to, if someone gets a grand jury subpoena, to have them instead do a proffer with the government where the person essentially gets a one-day immunity where he or she can talk to the government. The information cannot be used against him or her as long as he or she tells the truth. That's a big caveat. And then hopefully you're on your way and you're fine, and they might still put you in front of the grand jury, but it's better to get that process done. And if you're put in front of the grand jury, the way it works is that you testify, you ask questions, you testify, your attorney can't be with you, but you have your attorney outside of the grand jury room, so that way if you have any questions or concerns, the witness can come out and talk to his lawyer. And something I found is that it's very important and it's very reassuring to clients, is that usually, whether it's the FBI, U.S. Attorney's Office, whomever it is, tend to be very good about, if you ask straight up, is my client just a witness, a subject of investigation, which means somebody who they think may or may not be guilty of a crime, but they're choosing at that point not to indict him or her, or a target, which means they're focusing their attention on that person, hoping to indict the person. And usually they're straight up and they'll tell you, no, your client is just a witness, and that's very reassuring. And I find that my clients are very reassured when they find that out. And whereas sometimes when they're on their own, they're just scared.
Now let's talk about where someone in that situation may go wrong, may go astray, may do a disservice to themselves. Typically with a grand jury subpoena, but not always, and certainly with regard to meetings with the U.S. Attorney in lieu of grand jury appearances, the prosecutor will want document production. Now, in your opinion, is it wise for the witness to spend the time and money to go over those documents with their attorneys to make sure nothing's left out?
Yes, I think it's very important. The thing is that there's two ways to look at this. One way is that the client and person who's subject to the grand jury subpoena has to turn over the documents that are in the subpoena. There's very little discretion and they must be turned over. But one thing the attorney enables the witness to do is to point out flaws in the case, things that the government's going to want to look at, things that might seem a little suspicious, even if the person is just a witness. Or, one problem that tends to happen is that witnesses go in, they talk to the AUSA or FBI agent, whomever it is, and either they lie because they're afraid of something or that they shouldn't be afraid of, or the witness will want to protect other people. So it's important to make sure with your attorney that you're being you be straight up with your attorney, and that the attorney identifies how, and obviously your attorney's not going to encourage you to lie. That's obviously the big thing, is to encourage the client not to lie, but at least know how to focus his or her testimony.
Now, in today's day and age of document management, often relevant evidence and documents are stored on computers and networks. If the budget is available, does it ever make sense to get a computer forensics expert involved? Again, if it's a privacy issue or some sort of records expert who knows how to access and search emails, for example, would be a typical issue that would come up. Does that make sense to do if there's a budget for it?
Yes, that's something that comes up. If there's thousands and thousands of documents, and it might be very difficult and expensive for the client and even the law firm itself in order to pull all the documents and sort all the documents. It can be good to get a computer person in, and then also a doc review team to try to make sure you're able to gather all the documents that are there. One of the worst things to do is to miss a material document. The document it's very important, and then the government gets it from another person or finds out some way later on and says, well, why didn't you turn this over? And you don't want to. That's just a way to get in hot water. So it's good to have somebody who comes in, make sure you have all the documents, turn over all the documents, and do a process to review them, even though there are so many. Because sometimes they'll ask for all email communications with people you've done business with for 5-6 years, and there could be tens of thousands of emails.
I think the point we want to make is, it may be expensive, but don't be, what is the saying?
Penny wise
and a pound foolish. Because once you get off on the wrong foot with the prosecutor, you may end up being prosecuted yourself. The final question I want to get into is another common scenario that witnesses are faced with, and that is, should they speak with the target, other targets, their attorneys? I know there's no one-size-fits-all answer, but in general, is there a general piece of advice that you can give? Because oftentimes the targets are the people who are actually in hot water, who will be prosecuted, of course, really, really want to know what the government is talking to witnesses about. So what is your take on that?
I can give a one-word, very simple answer: don't. There's the first question, not the first question, but one of the first questions the government will ask is, when's the last time you've spoken to, and they'll go through all the people who they're looking at. And so what you don't want to say is, if it's the truth, it's the truth, but you'd rather not be saying, yeah, I spoke to Mr. Target yesterday about what my testimony would be, and that's not the good answer.
All right, well, I think that's it for this week. We kind of gave Steve the week off, but I'm sure he doesn't mind. We'll catch up with you next week, hopefully, on the Raines-Feldman Cyber Liability Update.